Hello and welcome to Bar 10, Lesson 10, where it's our goal to help you prepare for the bar exam 10 questions at a time. Don't forget to like, subscribe, and ring the notification bell so that we can update you every time we upload new content. Let's get started with question number 1. Sal owned 5 adjoining rectangular lots, numbered 1 through 5, inclusive, all frontings on Main Street. All of the lots are in a zone limited to 1 and 2 family residences under the zoning ordinances. 2 years ago, Sal conveyed lots 1, 3, and 5. None of the 3 deeds contain any restrictions. Each of the new owners built a one-family residence. 1 year ago, Sal conveyed lot 2 to Peter. The deed provided that each of Peter and Sal, their respective heirs and assigns, would use lots 2 and 4 respectively only for one-family residential purposes. The deed was promptly and properly recorded. Peter built a one-family residence on lot 2. Last month, Sal conveyed lot 4 to Betty. The deed contained no restrictions. The deed from Sal to Peter was in the title report examined by Betty's lawyer. Betty obtained a building permit and commenced construction of a 2-family residence on lot 4. Peter, joined by the owners in lots 1, 3, and 5, brought an appropriate action against Betty to enjoin the proposed use of lot 4, or alternatively, damages caused by Betty's breach of covenant. Which is the most appropriate comment concerning the outcome of this action? 1. All plaintiffs should be awarded their requested judgment for injunction because there was a common development scheme, but award of damages should be denied to all. B. Peter should be awarded appropriate remedy, but recovery by the other plaintiffs is doubtful. C. Injunction should be denied, but damages should be awarded to all plaintiffs, measured by diminution of market value, if any, suffered as a result of the proximity of Betty's 2-family residence. Or D. All plaintiffs should be denied any recovery or relief because the zoning preempts any private scheme of covenants. Take 10 seconds and choose the best answer. If you chose B, Peter should be awarded appropriate remedy, but recovery by the other plaintiffs is doubtful, you'd be correct. The rule is that for the burden of a covenant to run with the land, the following elements must be satisfied. 1. Writing. 2. Intent of the original parties. 3. Touch and concern the land. 4. Horizontal and vertical privity. And 5. Notice. In this case, Sal conveyed lot 2 to Peter, and the deed provided that each of Peter and Sal, their respective heirs and assigns, would use lots 2 and 4, respectively, only for one-family residential purposes. This covenant is in writing. Sal and Peter intended the covenant to run with the land. The covenant touches and concerns the land. Horizontal and vertical privity exists, and Betty had record notice of the covenant since the deed conveying lot 2 to Peter was promptly and properly recorded. As such, Peter would prevail in an action against Betty to enforce this covenant. The owners of lot 1, 3, and 5, on the other hand, would not recover because Sal never promised these owners that the lots would be used only for one-family residential purposes. So as a result, the correct answer would be letter B. Question number 2. Mom rushed her 8-year-old daughter to the emergency room at a hospital after the child fell off her bicycle and hit her head on a sharp rock. The wound caused by the fall was extensive and bloody. Mom was permitted to remain in the treatment room and held the child's hand while the emergency room physician cleaned and sutured the wound. During the procedure, Mom said that she was feeling faint and stood up to leave the room. While leaving the room, Mom fainted and, falling, struck her head on a metal fixture that protruded from the emergency room wall. She sustained a serious injury as a consequence. If Mom sues hospital to recover damages for her injury, will she prevail? A. Yes, because Mom was a public invitee of hospitals. B. Yes, unless the fixture was an obvious, commonly used, and essential part of hospitals' equipment. C. No, unless hospitals personnel failed to take reasonable steps to anticipate and prevent Mom's injury. Or D. No, because hospitals personnel owed Mom no affirmative duty of care. Take 10 seconds and choose what you believe to be the best answer. If you chose option C, you'd be correct. No, unless the hospital personnel failed to take reasonable steps to anticipate and prevent mom's injury. The rule for invitees, i.e., persons invited onto the land to conduct business with the owner or persons invited as a member of the public for purposes of which the land is held open to the public, is that activities must be conducted with reasonable care. There is a duty to inspect with reasonable care the land for hidden dangers, and there is a duty to warn known concealed dangers. In this case, mom was at the hospital to conduct business, i.e., receive medical treatment for her 8-year-old daughter. So mom is an invitee. This requires that hospital conduct activities with reasonable care, that hospital inspect the premises with reasonable care for hidden dangers, and that hospital warn mom of known concealed dangers. As such, mom will only prevail in her action to recover damages for her injury if hospital's personnel fail to take reasonable steps to anticipate, i.e., inspect with reasonable care, and prevent mom's injury. Question number 3. Buyer Inc. contracted in writing with shareholder who owned all of XYZ Corporation's outstanding stock to purchase all of her stock at a specified price per share. At the time this contract was executed, buyer's contracting officer said to shareholder, "Of course our commitment to buy is conditioned on our obtaining approval of the contract from Conglomerate Limited, our parent company." Shareholder replied, "Fine, no problem. For this question only, assume that Conglomerate orally approved the contract, but that shareholder changed her mind and refused to consummate the sale on the two grounds, one being when the agreement was made, there was no consideration for her promise to sell, and 2, Conglomerate's approval of the contract was invalid. If buyer sues shareholder for breach of contract, is buyer likely to prevail? A, yes, because buyer's promise to buy, bargained for and made in exchange for shareholder's promise to sell, was good consideration even though it expressly conditioned on an event that was not certain to occur. B, yes, because any possible lack of consideration for shareholder's promise to sell was expressly waived by shareholder when the agreement was made. C, no, because mutuality of obligation between the parties was lacking when the agreement was made. Or D, no, because the condition of Conglomerate's approval of the contract was an essential part of the agreed exchange and was not signed or in writing. Take 10 seconds and choose what you believe is the best answer. If you chose option A, you'd be correct. Yes, because buyer's promise to buy, bargained for and made in exchange for shareholders' promise to sell, was good consideration, even though it was expressly conditioned on an event that was not certain to occur. The rule is that a conditional acceptance terminates the offer and becomes the new offer. Consideration is the bargain for exchange between parties. As such, when the shareholder replied, "Fine, no problem," the new offer by buyer was accepted by shareholder and created a valid contract because buyer's promise to purchase all of shareholder stocks was good consideration, even if the promise was expressly conditioned on the approval of the parent company. Question number 4. A city ordinance requires a taxi cab operator's license to operate a taxi cab in King County. The ordinance states that the sole criteria for the issuance of such a license are driving ability and knowledge of the geography of King County. An applicant is tested by the city for these qualifications with a detailed questionnaire, written and oral examinations, and a practical behind-the-wheel demonstration. The ordinance does not limit the number of licenses that may be issued. It does, however, allow any citizen to file an objection to the issuance of a particular license, but only on the ground that an applicant does not possess the required qualifications. City licensing officials are also authorized by the ordinance to determine, in their discretion, whether to hold an evidentiary hearing on an objection before issuing a license. Sandy applies for a taxicab operator's license and is found to be fully qualified after completing the usual licensing procedures. Her name is then posted as a prospective licensee, subject only to the objection process. John, a licensed taxicab driver, files an objection to the issuance of such a license to Sandy solely on the ground that the grant of a license to Sandy would impair the value of John's existing license. John demands a hearing before a license is issued to Sandy so that he may have an opportunity to prove his claim. City licensing officials refuse to hold such a hearing, and they issue a license to Sandy. John petitions for a review of this action by city officials in an appropriate court, alleging that the Constitution requires city licensing officials to grant his request for a hearing before issuing a license to Sandy. In this case, the court should rule for A. John, because the Due Process Clause of the 14th Amendment requires all persons whose property may be adversely affected by governmental action to be given an opportunity for a hearing before such action occurs. B. John, because the determination of whether to hold a hearing may not be constitutionally left to the discretion of the same officials whose action is being challenged. C. City officials, because John had the benefit of the licensing ordinance and therefore may not now question actions taken under it. Or D. City officials, because the licensing ordinance does not give John any property interest in being free of competition from additional licensees. Take 10 seconds and choose the best answer. If you chose option D, you'd be correct. City officials, because the licensing ordinance does not give John any property interest in being free of competition from additional licensees. The rule is that the government cannot deprive a person of life, liberty, or property without due process. The government must provide a fair process or procedure before it may deprive a person of life, liberty, or property. Property deals with the loss of an entitlement, i.e. a reasonable expectation to continue receipt of some benefit. In this case, John objected solely on the ground that the grant of the license to Sandy would impair the value of John's existing license. However, the ordinance specifically does not limit the number of licenses that may be issued, so John would have no reasonable expectation to be free of competition. Question number 5. Defendant is on trial for the murder of his father. Defendant's defense is that he shot his father accidentally. The prosecutor calls witness, a police officer, to testify that on 2 occasions in the year prior to this incident, he had been called to defendant's home because of complaints of loud arguments between defendant and his father, and had found it necessary to stop defendant from beating his father. The evidence noted above is A. Inadmissible, because it is improper character evidence. B. Inadmissible, because witness lacks firsthand knowledge of who started the quarrels. C. Admissible, to show that defendant killed his father intentionally. Or D. Admissible, to show that defendant is a violent person. Take 10 seconds and choose the best option. If you chose option C, admissible to show that defendant killed his father intentionally, you'd be correct. The general rule is that evidence of a person's character or a trait of character is not admissible for the purposes of proving action in conformity therewith on a particular occasion. In a criminal case, no character evidence admissible during the prosecution's case in chief. The prosecution can only rebut character evidence introduced by the defendant first. However, specific instances of defendant's prior bad conduct can be admissible to prove a mimic fact, such as A. Motive, B. Intent, C. Absence or mistake of accident, D. Identity, or E. Common plan or scheme. In this case, the prosecutor calls witness, a police officer, to testify that on 2 prior occasions in the year just before this incident, he was called to the defendant's home because of complaints of loud arguments between the defendant and his father, and it found it necessary to stop defendant from actually beating his father. Since the prosecution introduced this evidence, it cannot be used to prove the defendant's violent character. This evidence, however, can be introduced as a mimic fact to prove the defendant's intent to kill his father and or absence of an accident. As such, the evidence is admissible to show that the defendant killed his father intentionally. Abel owned Blackacre in fee simple. 3 years ago, Abel and Betty agreed to a month-to-month tenancy, with Betty paying Abel rent each month. After 6 months of Betty's occupancy, Abel suggested to Betty that she could buy Blackacre for a monthly payment of no more than her rent. Abel and Betty orally agreed that Betty would pay $25,000 in cash, the annual real estate taxes, the annual fire insurance premiums, and the costs of maintaining Blackacre. plus the monthly mortgage payments that Abel owed on Blackacre. They further orally agreed that within 6 months, Betty could pay whatever mortgage balances were then due, and Abel would give her a warranty deed to the property. Betty's average monthly payments did turn out to be about the same as her monthly rent. Betty fully complied with all of the obligations she had undertaken. She made some structural modifications to Blackacre. Blackacre is now worth 50% more than it was when Abel and Betty made their oral agreement. Betty made her financing arrangements and was ready to complete the purchase of Blackacre, but Abel refused to close. Betty brought an appropriate action for specific performance against Abel to enforce their agreement. The court should properly fine for A. Abel, because the agreements were oral and violated the statute of frauds. B, for Abel, subject to the return of the $25,000 because the arrangement was still a tenancy. C, Betty, because the doctrine of part performance applies. Or D, Betty, because the statute of frauds does not apply to oral purchase and sale agreements between landlords and tenants in possession. Take 10 seconds and choose what you believe to be the best option. If you chose option C, Betty, because the doctrine of part performance applies, you'd be correct. The general rule is that transfers of interest in land are governed by the statute of frauds, and as such, must be in writing. Part performance, however, can create an exception to this general rule if there's a clear and definite oral contract, and two of the following three conditions are met. 1, buyer takes possession. 2, buyer pays all or part of the purchase price, and or 3, buyer makes substantial improvements to the land. In this case, there's a clear and definite oral contract, and Betty took possession of Blackacre, and she made structural modifications to Blackacre. So the exception to the general rule would apply. As such, the court should rule for Betty because her part performance is sufficient to satisfy the statute of frauds requirement. Let's move on to question number 7. For 10 years, vacationer and neighbor have owned summer vacation homes on adjoining lots. A stream flows through both lots. As a result of a childhood swimming accident, vacationer is afraid of water and has never gone close to the stream. Neighbor built a dam on her property that has completely stopped the flow of stream to vacationer's property. In a suit by vacationer against neighbor, will vacationer prevail? Here are your 4 choices. A, yes, vacationer will prevail if the damming unreasonably interferes with the use and enjoyment of vacationer's property. B, yes, vacationer will prevail if neighbor intended to affect vacationer's property. No, vacationer will not prevail because vacationer made no use of the stream. Or D, no, vacationer will not prevail if the dam was built in conformity with all applicable laws. Take 10 seconds and see what you believe to be the best option. If you chose A, yes, if the damming unreasonably interferes with the use and enjoyment of vacationer's property, you'd be correct. A private nuisance is an unreasonable interference with the plaintiff's use and enjoyment of her land. The defendant will be liable if her conduct is negligent, abnormally dangerous, or intentional. In this case, vacationer will need to show that neighbor's dam unreasonably interferes with vacationer's use and enjoyment of the land in order to establish that the dam is a private nuisance. Neighbor did not have to intentionally affect vacationer's property in order to be liable. Additionally, neighbor's dam may comply with all applicable laws but still unreasonably interfere with vacationer's use and enjoyment of the land. Vacationer's use and enjoyment of the land could be negatively impacted by the dam even though vacationer is afraid of water and has never gone close to the stream. As such, vacationer will prevail if the damming unreasonably interferes with the use and enjoyment of vacationer's property. Question number 8. Buyer Incorporated contracted in writing with shareholder who owned all of XYZ Corporation's outstanding stock to purchase all of her stock at a specified price per share. At the time this contract was executed, buyer's contracting officer said to shareholder, "Of course our commitment to buy is conditioned on our obtaining approval for the contract from Conglomerate Limited, our parent company." Shareholder replied, "Fine, no problem." For this question only, assume the following facts. Shareholders subsequently refused to consummate the sale on the ground that buyer had neglected to request conglomerate's approval of the contract, which was true. Conglomerate's chief executive officer, however, is prepared to testify that conglomerate would have routinely approved the contract if requested to do so. Buyer can also prove that it has made a substantial sale of other assets to finance the stock purchase, although it admittedly had not anticipated any such necessity when it entered into the stock purchase agreement. If buyer sues shareholder for breach of contract, is buyer likely to prevail? A, yes, because the condition of conglomerate's approval of the contract being designed to protect only buyer and conglomerate can be and has been waived by those entities. B, yes, because buyer detrimentally relied on shareholders' commitment by selling off other assets to finance the stock purchase. C, no, because the express condition of conglomerate's approval had not occurred prior to the lawsuit. Or D, no, because obtaining conglomerate's approval of the contract was an event within buyer's control, and buyer's failure to obtain it was itself a material breach of contract. Take 10 seconds and choose the best answer. Correct answer is A, yes, because the condition of conglomerate's approval of the contract being designed to protect only buyer and conglomerate can be and has been waived by those entities. An express condition is language in a contract that states something must occur before someone's performance is due. If the condition is not satisfied, non-performance is excused. The party who is protected by an express condition, however, may waive that condition. In this case, the express condition that buyer would have to first obtain approval of the contract from conglomerate is protecting buyer and conglomerate. As such, they may waive the express condition because they are the parties protected by it. Thus, buyer is likely to prevail because the condition of conglomerate's approval of the contract being designed to protect only buyer and conglomerate can be and has been waived by those entities. Question number 9. A statute of state X's permits a person's name to appear on the general election ballot as a candidate for statewide public office if the person pays a $100 filing fee and provides proof from the state elections board that he or she was nominated in the immediately preceding primary election by one of the state's two major political parties. It also permits the name of an independent candidate or a candidate of a smaller party to appear on the general election ballot if that person pays a filing fee of $1,000 and submits petitions signed by at least 3% of the voters who actually cast ballots for the office of governor in the state of X election. State X maintains that these filing requirements are necessary to limit the size of the election ballot, to eliminate frivolous candidacies, and to help finance the high cost of election. Historically, very few of State X's voters who are members of racial minority groups have been members of either of the two major political parties. Recently, a new political party has been formed by some of these voters. Which of the following constitutional provisions would be most helpful to the new political party as a basis for attacking the constitutionality of the statute of State X? A, the First Amendment, B, the 13th Amendment, C, the 14th Amendment, or D, the 15th Amendment. Take 10 seconds and choose the best option. Correct answer is C, the 14th Amendment. The First Amendment states Congress shall make no law abridging the freedom of speech. This was made applicable to states and local governments through the 14th Amendment. Preventing the new political party from appearing on the ballot would be a freedom of speech issue. And since we're dealing with a state, it would be the 14th Amendment, not the First Amendment. That would provide the new political party a basis for attacking the constitutionality of State X's statute. Please remember that all other amendments are applied to the states via the 14th Amendment and through the 14th Amendment alone. And our final question for this grouping, question number 10. Plaintiff is suing doctor for medical malpractice occasioned by allegedly prescribing an incorrect medication, causing plaintiff to undergo substantial hospitalization. When doctor learned of the medication problem, she immediately offered to pay plaintiff's hospital expenses. At trial, plaintiff offers evidence of doctor's offer to pay the cost of his hospitalization. The evidence of doctor's offer is A, admissible, as a non-hearsay statement of a party. B, admissible, although hearsay, as a statement against interest. C, inadmissible, because it is an offer to pay medical expenses. D, inadmissible, because it is an offer to compromise. Take 10 seconds and choose the best answer. Best answer is C, inadmissible, because it is an offer to pay medical expenses. An offer to pay medical expenses is inadmissible to prove liability for injuries in question, but related statements are still admissible. Here, doctor offered to pay plaintiff's hospital expenses. Doctor's offer is inadmissible to prove liability for plaintiff's injuries. Accordingly, C is the best answer. Thank you once again for joining us on Bar 10, where it's our goal to help you prepare for the bar exam 10 questions at a time. We upload content every day. Please like, subscribe, and click the notification bell so that you can be updated every time we upload new content.